Welcome everyone to the Environmental Law Institute's last in-person session of summer school this year on environmental justice. We're so excited to see some of you in the room today, as well as many folks online. If you have been following along with ELI's summer school series, this is our fourth and last in-person session, but we have two more left to go that will be webinar only on hazardous waste and sites, and then as well on disaster and mitigation law. So please tune into those in the next couple of weeks. If you would like, if you've missed any portions of summer school, you can find them all on our website. All sessions of summer school are recorded and open to the public to watch later. So be sure to check out any sessions on this list behind me that you have that you may have missed. Thank you all so much, and I will now go ahead and introduce today's wonderful moderator, Margaret van Rotz. Van Rotz is a public interest environmental law fellow here at ELI. She is an Indigenous scholar from the Philippines and California. Margaret holds a JD from UC Law San Francisco and an LLM in Environmental Law and Sustainable Development from SOAS University of London. While in law school, Margaret clerked at Earth Justice in their DC office, remotely externed at the Pacific Community in New Caledonia and at the Climate Litigation Network in the Netherlands, and was a research assistant for Professor Dave Owen. Prior to law school, Margaret was a special education teacher in Hawaii and co-founder of Indigenous Knowledge, Art, and Truth. I'll hand things over to you, Margaret. Thank you so much.
Thank you. If I could get the clicker back. Thank you. Welcome, everyone. It's so nice to have people in person and online. I'm just going to start with some quick introductions of our speakers and then do a quick rundown of the agenda and then get right into it. So I'm going to start with the person on my left. We have Sheronda Rose with us today.
Good afternoon.
Sheronda is a litigation attorney at the Chesapeake Bay Foundation, where she leads legal efforts focusing on administrative and judicial actions related to discharge permits, environmental justice, and land use throughout the Chesapeake Bay watershed. Sheronda brings over a decade of legal and legislative experience across federal, state, and nonprofit sectors. Prior to becoming an attorney, she worked on regulatory and energy policy with the U.S. Fish and Wildlife Service and in the DOJ Civil Rights Division. And she worked for several years with the Maryland National Capital Park and Planning Commission, providing legal and legislative support to the Office of the General Counsel on parks and recreations issues, land use, and litigation. Sheronda is also a professional lecturer at the George Washington University's Paralegal Studies program and is currently the chair of the Pro Bono Task Force for ABA SEER, or Section of Environment, Energy, and Resources. And then we also have Stacey with us.
Hi, everyone.
Stacey Halliday is a partner at Arnold and Porter and has more than a decade of experience in environmental law, regulatory compliance, and enforcement defense. A former senior member of the Environmental Protection Agency's Oversight Response Team, she draws on a deep well of government and private sector insights to advise clients navigating complex environmental challenges. In addition to her environmental regulatory practice, Stacey advises clients on ESG and environmental justice matters with expertise involving voluntary and mandatory disclosures, sustainability ratings, environmental marking claims and litigation, such as recycled content and recyclability, and environmental justice strategy and state compliance. She also serves as a co-chair of the firm's ESG working group. Stacey is also on the board of directors for ELI and is special advisor for the ABA Environmental Justice Task Force. So we're all excited to have you here today and get to talk to you about environmental justice. Here's what the agenda is going to look like. We just ran through introductions. We're going to go through some of the history and foundations of EJ, especially for those in the room that aren't as familiar with the term. Then we'll get into kind of the elephant in the room, which is everything that's been happening the last, 6-7 months, talking about what's happening on the federal level. But the federal level is not the only important part when it comes to EJ. We'll also talk about state and tribal laws and regulations. And we'll get into what EJ litigation and enforcement is starting to look like. And then just kind of summarize, give some key takeaways, and hopefully have time for a really robust discussion. The way that we're going to kind of run through our program here is we will have slides to kind of help give you some visuals and get down the key points, but as much as possible, we want this to be conversational. So you'll be seeing me ask a lot of questions to our speakers here to kind of help prompt the conversation and kind of guide us through what will be hopefully a really robust and interesting conversation. So if you have any questions in the room, please hold on to them until Q&A, and I'll be sure to get to them. And for those of you online, just a reminder to ask in the Q&A, and I'll check those out when we get to the Q&A section. So with that, before we dive into the terminology and history behind environmental justice, Sheronda, I was hoping you could walk us through what justice generally means, or in this case, types of injustice. What does that mean for historically marginalized communities?
Sure. First, I want to thank ELI for having me as a part of this panel. I've always been a big fan of the summer school session and learned a lot. So thank you for providing that valuable resource to our community. And thinking about justice, I thought it would be important to acknowledge up front that justice looks different for different groups and different communities. And in thinking about justice, you want to apply some of these aspects that have been studied by scholars working on EJ issues. And when I was learning about EJ during my time in law school, I found this very helpful to kind of conceptualize and give me some background on what justice looks like in terms of distributive injustice. And this is from Professor Robert Kuhn's taxonomy of environmental justice. And this builds upon work by some of the giants in the environmental justice movement, such as Dr. Robert Ballard and other professors. And it starts off with talking about distributive injustice. So thinking about exposure to environmental hazards and how that is disproportionate among communities and what that looks like when you think about environmental hazards, such as pollution from facilities and siting of landfills, those sorts of choices that impact communities, and also the environmental benefits and amenities that communities sometimes miss out on, having access to green space and infrastructure and utilities that support their day-to-day needs. We'll talk about concepts of procedural unfairness, and this is looking at the process and how community input is being considered, making sure that there's not exclusion of certain groups from the process, offering things like public hearings, taking public comments, and really allowing for the public to be involved and engaged to give their input, as well as to receive information about decisions that are going to affect their communities and their day-to-day lives. The topic of corrective injustice will come up, and this pertains to enforcement and at times enforcement of environmental laws. While we have many robust laws at our disposal, at times they are not enforced consistently to protect all communities. So corrective injustice focuses on that. And then we'll also talk about concepts of social injustice, and environmental degradation and harms are intertwined with social ills, poverty, issues of lack of generational wealth and access to resources. So thinking about how that kind of exacerbates environmental justice issues. Go ahead to the next one.
So with that, now that we have a kind of a basic understanding of what justice can look like, what do we mean by environmental justice, and where does the term come from?
Sure. So with environmental justice, we still are using this definition here that was set forth by the US EPA. And it talks about the fair treatment and meaningful involvement of all people, regardless of their race, color, national origin, income, with the aspect of developing and implementing, enforcing environmental laws and regulations and policies. So the EPA definition has been widely adopted amongst the states and local governments. So with that definition, we start to think about some of these key terms that come along with that. Thinking about marginalized communities, communities that have been typically left out historically of some conversations when it comes to environmental issues and not having their needs considered. We'll also talk about the concept of meaningful involvement, what that looks like with having the public able to participate and have the opportunity to have their voices heard, and also to have action taken to address their concerns as well. We'll also talk about fair treatment. So environmental justice, when you think about fair treatment, you also think about terms such as equity and making sure that no one particular group is bearing a disproportionate burden when it comes to environmental stressors and things in their environment. And then we'll think about the concept of overburdened communities. So when you think about minority communities, tribal communities, and indigenous populations that historically have experienced a disproportionate environmental harm or risks due to cumulative impacts, we'll talk about that next, of multiple sources of pollution in their communities that kind of just build upon one another and make it difficult for them on their day-to-day lives. So with cumulative impacts, you consider that when you are looking at siting of facilities, what are all of the universe of sources of pollution that a community is experiencing.
Jump in real quick.
Yeah,
here.
please do.
I think this is always helpful to do a level set, but I feel like you could have a EJ 101 full chapter on just the definition section to get into how do we talk about environmental justice, what we mean by an EJ community or community facing an EJ challenge or concern. And a big part of this is the EPA definition is really the longstanding, most widely used, I think, definition by both states and prior to recently federal agencies. But it really depends on what your jurisdiction is or what stakeholders you're talking to when you're talking about environmental justice. There are plenty of contacts that I have and friends in the advocacy community who don't like this definition at all by EPA and have challenged it for a very long time. On the flip side, the Biden administration introduced its first definition of the first federal definition of environmental justice only a few years ago that included something as broad as sort of a right to a clean and healthy environment, which is sort of what we see more in environmental rights amendments or over in Europe. So just, it really, it fluctuates and broadens depending on what you're talking about. But this definition, and I think Sheronda's going to get more into the history here, started out as environmental racism, which makes it very, I think, specific to a US concept, even though it's defined differently in different states overseas, and really does vary widely. Just flagging that.
Yes, thank you. And many of these key terms and the definition here have recently come under attack or been, kind of considered taboo in the current day. And so we'll talk about how that transition came about when we discuss the history of the environmental justice movement and where we are today.
That's perfect. Right into our next slide. So, you've given us some of the terminology, but really like where have we started? And then, so I'm going to have Sheronda kind of give us where environmental justice movement started, some of like the key developments, and if you could take us up to the Biden administration. And then I'm going to have Stacey kind of take us through like specifically the last 5 years, because there has been a lot of movement. And then we'll do that and then set us up for the next part of the conversation, which is, I'm sure, the elephant in the room everyone wants to talk about, which is what's happening currently. We just need to have the build up first. So Sheronda, if you want to take it away.
So for environmental justice, typically everyone considers the roots to come from the civil rights movement here in the United States, spurring from the 60s and the 70s. And during that time, environmental justice principles were kind of based in civil rights and those aspects. And that transitioned into the 1980s with the Warren County landfill protest. This was 1983 in Warren County, North Carolina. And the decision was made to site a landfill to hold hazardous PCB waste within the community. And Warren County was the poorest county within the state of North Carolina, and was also near a predominantly Black community called Afton. And so the community rallied to express their concerns about the siting. They found out about it as it's happening. They weren't engaged on the forefront. They weren't able to express their concerns and didn't feel like they were really heard out in terms of this final plan. And they protested, and ultimately this went on for weeks. The facility was still sited in their community, but this movement, the grassroots movement, and how a multi-coalition came together to collaborate, to raise their voices, this really sparked the environmental justice movement on the national level to give more exposure around environmental justice and how siting issues predominantly affected poor minority communities. So that was 1983, and moving into continuing to organize. In 1991, there was the first National People of Color Environmental Leadership Summit, which was held in October in Washington, D.C. And this was a coalition of predominantly, I think, almost 300 Black, Native, Latino, Pacific Islander, Asian Americans, and other minorities come together and discuss, for the first time, environmental injustices experienced in their communities and try to think about how they could deal with those. So from this leadership summit, they laid forward 17 principles of environmental justice, and there was a greater, larger conversation beginning to happen around environmental justice. So a few years after that, in 1994, we had the issuance of Executive Order 12898 during the Clinton administration. It was titled Federal Actions to Address Environmental Justice in Minority Populations and Low-Income Populations. And the purpose was to focus at the federal level attention on environmental and health effects from some of these different decisions and start to consider environmental justice at the federal level. Specifically, this directed the agencies to identify and address disproportionate and high adverse human health effects, think about permitting and dealing with these issues to the greatest extent allowed under the law, developing a strategy for EJ implementation. It also established an interagency working group on environmental justice. So you see a lot more federal activity and attention with concrete plans being laid forth to address environmental justice. So Stacey, I'll let you kind of dive into the Biden administration and some of the developments there.
All right. So with the Biden administration, there was a lot of work that was obviously being done to advance environmental justice. You go from sort of, a time of protest to a time of data collection with the GAO report and toxic waste and race, looking at data showing disproportionate impacts in certain communities, and then get into 12898 for the first federal recognition of environmental justice on the federal stage, starting to build out that infrastructure with an Office of Environmental Justice at EPA and whatnot. Then the Biden administration, supercharged all of that activity in 4 years. You had this whole of government approach to environmental justice, which somebody who spent a couple of years at EPA working on EJ issues, this was a seismic change, and I think other former colleagues underscored that point, the experiences they were having. From day one of the administration, there was a real clear message of we're going to pair environmental justice and climate activity at the highest levels of government. So from that, you had Executive Orders 14,008, which introduced a series of new programs and new entities, new resources, 14,096. Those are really the two really big executive orders, arguably, and a welcome dissent there, in the 4 years of Biden administration that really articulated clear programs, goals, initiatives, capacity expansion. So there are a couple of different buckets that the Biden administration advanced, or buckets of activities. I'd say new programs. The Justice 40 initiative was one that really looked at the idea of benefit distributions. We talk about the distributive injustice that Sheronda was talking about, less about the burdens and more about the benefits. Justice 40 committed the federal government to taking 40% of the benefits from climate investments across the federal family and directing them to disadvantaged communities as defined by the Council on Environmental Quality, the White House environmental shop. So J40 became this incredibly large program to think about how do agencies direct the benefits of these investments. New entities, the White House Environmental Justice Advisory Council, or the WEJAC, as a White House level, say, not version, because EPA had its NEJAC, its National Environmental Justice Advisory Council. The WEJAC took 20 plus environmental justice organizations, representatives from those groups, to directly advise the White House on issues involving environmental justice. Really interesting reports from the WEJAC on, they had a carbon management working group looking at CCUS, all sorts of targeted issues with real direct advice coming from these EJ organizations. New resources, like Climate and Economic Justice Screening Tool, or CGIST. More feelings there, also welcome thoughts. The CGIST tool was interesting because it was really developed to think about how do you define disadvantaged communities and how do you direct the benefits from this J40 program using federally available, publicly available data. There was quite a bit of controversy about the fact that it excluded race for reasons that we'll talk about, but essentially targeted these communities, these disadvantaged communities, by census block without thinking about race. But that's one of the tools. EJ Screen is a mapping tool that was expanded that's no longer available. And a host of other agencies also introduced new mapping tools to use data in ways to identify EJ communities, to identify equity gaps, and to really hone their programming to prioritize environmental justice. New funding, IRA and Bill, the Infrastructure Reduction Act and the Bipartisan Infrastructure Law, had incorporated requirements for environmental justice and equity-based investments. You saw agencies like the Department of Energy creating things called community benefits plans. Spent a lot of time working with clients on developing CBPs that really force thinking about how do you direct not just investments under J40, but how do you think about community engagement in a meaningful way? How do you do stakeholder assessments? Just really building out the language that federal funding recipients were using and thinking about. New leadership, our first, this is kind of bittersweet in the moment talking about this because we all know what's coming, but the first federal chief environmental justice officer at CEQ, Dr. Jalon White Newsom, building out EJ dedicated roles at FERC, DOJ introduced its first Office of Environmental Justice, with the Office of Environmental Justice and External Civil Rights elevated at EPA, where it was previously housed within other departments within the agency or other offices within the agency. It was elevated to its own, well, AA ship to its own office that reports directly to the administrator. More targeted enforcement, prioritizing disadvantaged communities for enforcement, using civil rights enforcement as a way to advance the interests of disadvantaged communities, and using imminent substantial endangerment authorities under environmental statutes to really prioritize EJ. And then finally, new rulemakings and guidance. So really trying to bake in EJ. So the folks were busy. And we set this up just to talk about sort of the swing of the pendulum, what happened over the last 4 years to the extent you were tracking it, and then to sort of lead into the swing back and how that's being approached by this administration.
I think that's a perfect segue into what we want to talk about next, which is where are we currently? The last, 6-7 months have obviously been quite tumultuous. I'm sure many of you in the audience have been like following along with the headlines, but in case you haven't, we want to give like a really good overview of what the recent rollbacks look like. So I'm going to start with Stacey. Can you give us, kind of the overview? What has the current administration done to roll back EJ, and maybe start by talking about like the relevant executive orders that we have there?
Sure. I mean, I think there were a series of executive orders from day one of the Trump administration that really targeted diversity, equity, and inclusion efforts by the federal government, by the Biden administration specifically, and appeared to conflate environmental justice, or at least align environmental justice as sort of an outcropping or subcategory of DE&I. So executive orders 14151, that one, let me just quickly say 14173 pulls back executive order 12898, which is sort of that foundational environmental justice EO from the Clinton era that was the authority for many different federal activities that advanced environmental justice. It's sort of most widely applied and most longstanding. Getting into 14151 was 14151 14173 is really the I don't want to say anti-DE&I federal EO, but really looks to eliminate DE&I efforts and environmental justice efforts and positions within the federal government. So sort of the full rollback of those capacity building efforts that were completed by the Biden administration. It explicitly calls out environmental justice as a target for those rollbacks. And I think it's worth noting also directs sort of an analysis by OMB, by AG, to really look at all of the programs within the federal government, all guidance documents, budgets, grants, not just that exist now, but also look back to those that existed before November 4th, 2024, with the goal of rooting out anything that might have been renamed, anything that might have been classified as something beyond environmental justice or DE&I. It's really an effort to root out that buildup over the last 4 years that we talked about, all those different pillars of investment and sort of capacity building. So what we see playing out after these EOs, and I think Sheronda, you're going to touch on this too, is the sort of the termination. A lot of this is happening, navigating litigation as well right now, being challenged pretty aggressively, but almost immediate termination or putting folks on administrative leave for those who were focused on DE&I or environmental justice. The Department of Energy's equity team was, I think, week 1 maybe put on admin leave, and those were the folks who were advising grant recipients on community benefits plans and that sort of thing. And I think EPA's Office of Environmental Justice was several weeks after that, and sort of less immediate succession. But we also lost the EJ screen mapping tool, CGIST, and jump in here in some of the capacity building narrowing.
Yeah, I would love to hear, like, specifically, we've got like how the executive orders have like set the tone. But yeah, if you could, Sheronda, if you could get into kind of more specifically what that capacity reduction looked like in some of the regulatory rollbacks.
Sure. Yeah, I'll start first with addressing some of the grant cancellations, because much of my work with ABA SEER and the Pro Bono Task Force, I saw the switch. I saw the shift in gears. So I started working on those issues back in 2023, where there was money flowing, from Bill and IRA. You mentioned that major, historic investment and reinvestment into communities nationwide. And it was a time where we were working to connect communities with resources, make sure they were aware of how to get grants, what the process was, compliance, and going through that process, meeting with my colleagues at USDA and talking about Forest Service grants and ways to kind of engage communities and make sure that they get these funds and improve their communities. And saw that shift with the new administration beginning and some of the EOs that were issued and the grants that were canceled, largely on the basis that they did not align with the administration's goals and priorities. So the shift went from helping people to get the money, make sure they were educated about it, to helping them defend their grants and keep that money and navigate that process. So we work with a lot of great organizations, largely the Environmental Protection Network and Lawyers for Good Government, on connecting communities with legal assistance to be able to navigate this time. And as Stacey mentioned, it's a lot of ongoing litigation. There's a lot of kind of up and down and tumult, a lot of different legal challenges to keep up with, but many great organizations doing the work on that front. And just keeping in touch with communities, learning about how they are impacted on a day-to-day basis, where they had money that they had used to go ahead with plans to hire staff or to purchase materials that they now can't use in implementing this project because they won't have enough money to complete it. So really just kind of being cut off in the middle of everything, chaos, not being able to access their funds. And as the litigation has gone on, some days the funds are accessible, they have like a portal they can go in and access, and just managing kind of the back and forth with getting that funding. So that has been something that smaller environmental justice organizations have really struggled with. So we've kind of worked to try and fill that gap and offer some support, and that's still ongoing. But specifically, the EPA Environmental and Climate Justice grants, that was $3 billion in IRA authorized grants. So we are, organizations are working to try and reinstate those funds. And with the regulatory and policy rollbacks, this has come over a realm of industries and also impacts specifically environmental regulations as well as climate-focused regulations that are being implemented at the federal agency level. So one of the trackers I found noted there were over 140 such actions. So let me find my note here. I want to make sure I don't miss. So it related to issues like methane emissions, limitation of pollution from cars and trucks, and also power plants, speeding up environmental review on drilling projects. We've seen changes proposed to 402 permitting to kind of accelerate being able to authorize some of these projects to garner the administration's goals on energy. And also some scale back of water efficiency standards, basic things down to stopping plastic straw bans and those sorts of initiatives. There's also some efforts to loosen rules around coal-fired plants and coal ash. And when you think about it, all of these regulatory changes will impact environmental justice communities the most. They are the least prepared to deal with the impacts of climate, as rollbacks are put in place that will affect policies that were ongoing. You think about clean car initiatives and how that's something that's ceased at the federal level. Some states are continuing to move forward on that. Things like green infrastructure and going in and preparing communities for like an energy shift. So seeing a lot of rollback on those topics.
And then before we move on, Stacey, can you briefly explain what is an enforcement rollbacks that we're seeing?
Yeah, sure. I promise I will answer your question.
Yes.
One thing, I forgot something earlier.
Go for it.
One, I was going to note I think just generally, the first Trump term did take some steps back or deprioritize things like environmental justice, but didn't necessarily target them, and definitely didn't roll back further sort of into the deep cuts of these sorts of authorities. So looking at things like the regulatory policy rollback. This administration is looking to undo the endangerment finding, which essentially gives EPA the authority to regulate greenhouse gases. So that's going to have second and third order impacts, potentially from a regulatory standpoint on sort of the regulatory protections that ultimately flow down to communities. That's something that could, but that's such a foundational thing. 12.898 is a sort of a fundamental foundational authority. The removal of EJ screen as a mapping tool, CGIS was brand new and people were just getting used to CGIS. People had lots of feelings about using CGIS. EJ screen was pretty baked in to how the agency did analysis, to how other agencies did their analysis, to how states did their analysis, to how many of my clients would think about, where do we target our priorities? How do we engage effectively? How do we access this information in the aggregate? So there are many states with mapping tools now, but removing some of these resources has really raised a lot of questions for compliance purposes and also just for operational purposes to say, how do we target and prioritize our work in this area as we continue to think about these issues, taking politics out of it. Just where do we get the information? Where can we rely on it? Even though a lot of this stuff is publicly available, how do you put it together? So I just wanted to flag that as just like a real life challenge. On the enforcement side, we've seen a couple different changes, just general changes in this administration's approach to enforcement, but also full rollbacks on civil rights enforcement that were used over the last 4 years, during the Biden administration to advance environmental justice goals. So you saw in those 4 years, DOJ took its first direct civil rights Title VI case. It's Title VI enforcement. Usually DOJ operates a certain more oversight capacity for Title VI civil rights enforcement, which prohibits the discriminatory use of federal funds on the basis of race, color, and national origin. So the way that would usually play out is EPA gives a grant, there's a federal funding recipient, they receive a complaint from a third party that says, hey, these funds are being used in a discriminatory manner, investigate it for X period of time, either find out that there's discrimination, they make that finding, and they can yank the funding. That's kind of how that normally would go. There were a lot more settlements, I think, in the Biden administration that was used more as a tool for investigation, particularly in places where there might not be a state-based environmental justice priority. You saw a lot of activity in Louisiana and Alabama. And in this administration, we've seen stepping back from those settlement agreements, the voluntary compliance agreements that were made by federal funding agencies, like DOJ in Alabama with Loudoun County, and reversals on litigation and more targeted action, like use of imminent substantial endangerment authority, which Clean Air Act, Water Act, CERCLA, basically emergency authority that was used in situations like Flint to kind of dive in and say, hey, the state's not prioritizing this issue. There's real danger for these communities. So the Biden administration used that authority quite often to try and advance environmental justice. And those sorts of challenges, those enforcement actions are largely being abandoned and rolled back by the Trump administration, like the federal suit against the Denga plant in Louisiana.
Safe to say it's not looking great at the federal level. Despite that, like obviously there are still EJ advocates who are litigating on these issues as we speak. I'm going to turn it over to Sheronda, and if you could answer for us, obviously using anything you need on the slide, but how are litigants proceeding with EJ cases, and what tools are at their disposal? When I think about like different tools, like obviously NEPA is one of them that's going to come up. Context, I've been working on a lot of NEPA issues here at ELI, and that's something that we've been talking about quite a bit is this the demise of NEPA? And our answer has been no. And similarly, like it's the same for EJ. So I can see how NEPA would be a tool for EJ communities. We do have some webinars on NEPA generally, but I would love to see like how these like environmental and or non-environmental statutes are being used by EJ communities currently for litigation.
Sure. So with NEPA, it requires federal agencies to assess and consider the environmental impacts of their actions when they're engaged in the decision-making process for projects, developments that will impact the environment. And so NEPA requires federal agencies to assess this in their proposed actions before they make decisions. So it's on the front end of whatever development is being considered to take time and assess how that's going to impact the environment, the communities there, So it's a tool that can be used to elevate and raise environmental justice issues and incorporate those into the process to make sure that stakeholders are aware and thinking about how they will address that before the project moves forward, and consider that during the process. So it can be a tool to assess different effects and consider impacts on EJ communities. So this is with permit applications. It also applies to federal land management actions, projects such as building, constructing major highways, and publicly owned utilities, all those sorts of developments. So with using the NEPA process, you evaluate the impacts on the environment, social and economic effects to communities. And this gives a chance for public review and engagement of the community for them to get their thoughts and concerns out. Oh,
You wanna jump in,
Jump
Stacey?
in.
Before you move off NEPA,
Yeah.
I was just gonna flag pre-Biden administration, all the guidance at the federal level pretty much lived in the NEPA space. So it was a lot of CEQ guidance that was really focused on NEPA, and promising practices and all that stuff was really focused in the NEPA context and applied more broadly across the federal family. So I just want to give NEPA guides a shout out.
Definitely. Yes, and there was environmental justice guidance specifically and under NEPA that was being used, and there's probably a PDF out there that's not tied to the main website, but you can still find that document and see the guidance that they provide to agencies who are crafting their NEPA guidance. And so with NEPA, recently there are proposed regulations to kind of roll back some of these protections with the goal of speeding up permitting and kind of providing a better space for development. So with those changes, I want to say it's only been out about a week or so. But it changes the requirements for agencies to kind of weigh in and incorporate some of these changes. So it's going to have a detrimental effect on EJ communities who aren't able to use those provisions and mechanisms to incorporate their concerns. So yes, Clean Water Act and Clean Air Act. So I spend most of my time litigating within the Clean Water Act space. But with these statutes, there are provisions built in to allow for citizen suits to enforce violations of the law. And so that goes with EPA enforcement, DOJ enforcement as well, to address the issues that communities face, specifically with the provisions provided for and those laws to address polluters and make sure that the agencies are doing their jobs when it comes to monitoring and enforcement and implementing some of these environmental protections. So how that typically looks with enforcement cases, you need to have data, there's data monitoring and collection on these different facilities to ensure compliance with permits, see where they are maybe exceeding benchmarks for a Clean Water Act permit, things like that. Monitoring of emissions built into the Clean Air Act. There's self-reporting from these entities. So there's a enforcement and compliance database that's housed online where you could go in, you could put in an address in your community and see what facilities are operating there. You could be able to pull up permits. There's also state level websites where you could go in and track this information. So tools for communities to be aware of what's operating in their facilities. Oftentimes there are requirements for facilities to publicly display their permits so that communities know where they can go to pull that information and monitor it. There's also investigations and site visits from the regulators to go in and assess compliance with terms. And with enforcement actions, you might end up having a notice of violation that goes out first. And during the enforcement process, it might develop into a process where there is a consent order that goes into place based on the facts found by the agency and what the problem is, and working to address those through consent orders. And there's also administrative orders and civil and criminal penalties as well that can come along with enforcement on these issues. So you can start to kind of build in some of the community remedies with these consent orders and address their concerns that way. So sometimes it incorporates some litigation projects, things of that nature. Community benefit agreements might be put in place to help address all their concerns. So, and then Administrative Procedure Act is also available to challenge arbitrary and capricious unlawful federal agency decisions. And I think Stacey, you might want to touch on a little bit of APA, but this particularly comes into play with regulatory rollbacks, some of those that we discussed prior to that impact vulnerable populations.
Well, one, shameless plug for any law students who are in the ether with us or here in the room. Take admin law if you haven't already taken it. It's painful, but it's so good and so helpful, especially now, so important. But with the APA and sort of thinking about sort of NEPA or the APA as sort of this procedural justice kind of strongholds of how our government works. It's interesting to see how executive orders recently have thought about these issues and are thinking about, like, just in April, directing the repeal of unlawful regulations, EO, which really directs agencies to identify unlawful or potentially unlawful regulations and look at them through the lens of recent Supreme Court decisions, including Loper Bright, which ELI has some great materials on Loper Bright if you haven't read it and you want some cliff notes, but essentially, you know, taking Chevron deference would give deference to agency decision making and discretion, and essentially taking that, flipping it on its head a bit and making this a review and repeal effort. So looking at rules across the federal government, regulations across the federal government, seeing where they don't necessarily align with the administration's priorities or with a finite list of particular Supreme Court decisions, which also includes the Harvard affirmative action case, Sackett v. EPA for the Clean Water Act, that's around of us. So really looking back at these regulations and saying, okay, well, what needs to go to advance administration's priorities? And then it goes further to basically say that these rules should be repealed without notice and comment, which is a sort of landmark part of the Administrative Procedures Act, which allows for stakeholders to comment on proposed rules. And essentially says that these repeals should be done without notice and comment under the good cause exception of the APA, which allows for, bypassing notice and comment where it would be impracticable, unnecessary, or contrary to public interest. So slightly subjective standard, but in essence, we've already seen that starting to happen. Just in May, DOE rolled back, there was a final rule issued to roll back DOE's anti-discrimination regulations. So that gets more into the Title VI Civil Rights Act, those independent agency regulations that govern how DOE investigates and adjudicates discrimination, and pulled out disparate impact, which we can get into if you guys want to in the Q&A, but that's a rabbit hole that has a long exit off the highway. But there was a 30-day comment period, which is extremely short. And we saw thousands upon thousands of comments submitted by a very diverse groups of stakeholders, just extraordinary response. And I don't know if it was causal, but the agency has decided to suspend the implementation of that final rule for 60 days. So just sort of an example of how bypassing notice and comment is really not only outside of the norm, but how we're going to see somewhat extraordinary situations play out from these deviations from common practice into the APA that could have downstream impacts as it concerns environmental justice, because there are fewer opportunities to comment for stakeholders.
And then I'll just add, before we move on from this slide, some of the challenges with litigating in this space. There can be limited standing, which is the right to bring the suit. So that's always, a hurdle that you have to make sure you can clear in terms of trying to bring and enforce an action. Making sure that there's access to legal representation for communities. And Stacey, you mentioned deference, judicial deference to the agency can be something that holds us back on some of these enforcement cases, because the court will rely upon, the agency's decision and their interpretation of statutes that they administer, particularly when you have scientific basis that plays into this. There's a big science piece at CBF. I work very closely with my scientists, and they hold my hand and treat me like I'm 8 years old. So, and break it down to me so that I can take it before the judge and do the same thing for them and answer some of the more scientific and technical questions, because it does have a big aspect in litigation, because you need to have that data to back up, your claims. So that's a challenge, and sometimes preemption with federal laws versus state laws, depending on where you're practicing the jurisdiction. That can be an issue, but it's a space that provides, some opportunities. There's new trends that are helpful with environmental litigation, greater consideration of cumulative impacts. There are a lot of youth climate suits gaining traction in the nation based on some statutory provisions available to them in different states. And also just taking a look at the use of data and mapping tools. So where we are losing some of those in the federal space, states do have some of those to kind of fill the gap and rely on. So we'll talk a bit more about what's going on at the state level.
You guys don't even need me. That's a perfect transition. We'll get to you.
So you made me think of so many different
I
things.
know.
There's so many things.
But I'm
to talk
gonna
about.
just
I know. I
hate
had
to be
that
all over
moment.
it, but
So many rabbit holes you can have. Please.
But, okay, so one thing that I thought you mentioned that was brilliant, and my aunt's an admin law professor, and she would have slapped me for how I quickly moved through Chevron deference and probably completely butchered it. But your point is such a good one in terms of deference being a hurdle, even on more of the community side, but also underscores that Loper and sort of the dissolution of Chevron deference now raises new questions about how that can be used. You think about it as something that would be used on the side to challenge environmental justice communities, but it certainly can be used in a lot of different ways. If you're removing agency deference at a time where there is an administration that might be taking action against certain EJ-related activities, it does open the door in other ways to, challenge those activities and not defer to the agency. So one flag that. I left out a key detail on the review and repeal piece, which really focuses on and does identify environmental justice related regulations and climate regs as targets for that review. So I just wanted to underscore that it's explicitly called out in the executive order. And the last thing I wanted to mention is your point on not so much citizen science, but the gap of mapping tools, I think is catapulting a lot of organizations that were supercharged over the last 4 years, got lots of funding, new partnerships across the WEJAG, across the country, like the Deep South Center for Environmental Justice, which is really, and We Act, really enormous organizations that have moved into sort of a federal stage and have done things like preserve federal mapping tools, create their own mapping tools, which raises, for regulated industry, for those who might be targeted by some of these challenges, for state permitting agencies, new challenges of where does this data come from? How do I challenge it? Where does it come? How is it reliable? And those same challenges for communities to say, how do we rely on defensible data in the absence of this gap? So I think in a litigation context, it's also an interesting conversation.
Right. And with data, there's always that question of, is this data reliable?
Right.
The agency pushing back on that. Talk about, capacity and ability to conduct the research needed and gather the data. But there are great spaces, in the academic world, the university space, where research is being done, and that data is, should be considered reliable. And so I think courts are kind of, sometimes you have to go in there and make that argument, and it's tough because the agency is given all this trust, and they're the experts, they have the expertise, they have the tools and resources. We saw that kind of come up recently in the San Francisco EPA. The EPA has all these resources, right? So with data that becomes problematic as well. And with citizen science, and you mentioned that, in collecting data, especially when you think about air quality monitoring, it's become much more affordable for communities to be able to purchase monitors and place those. So getting pushback on the reliability of that data can be an issue as well.
I love all of that. You actually made me think of two different points as well, particularly when it comes to Loper and potentially using it, there's that other benefit, right, of being able to use Loper. Like, well, if we're not going to defer to an agency, can EJ advocacy groups use that? And my hope is yes, and that's something that ELI has talked about in prior webinars on Loper Bright. I can't think of the name off the top of my head, but we do have like a team who's extensively looking at Loper and just kind of like recent Supreme Court cases and like how can we advance equity under those terms, even with those cases, even if they're not technically on the side of equity necessarily, but they can be used for other purposes. So, and that's something that I also noticed with a lot of NEPA advocates or people who litigators who are using NEPA, like they were kind of seeing it as like, we don't really see it as a demise of NEPA, especially because it's just kind of like the same thing, different day, just like a different term for it. So in many ways, it's not a dying like thing to use. But then the other thing I was thinking of, you're talking about like citizen science, and like one thing that I've noticed in my work at ELI is I do a lot of like toxic litigation tracking. And one issue that often comes up for marginalized communities is like just a lack of access to science and lack of access to community testing, especially. So how can they even, in terms of communities that are vulnerable, a lot of fence line communities to a lot of these like plants down in Cancer Alley, for example, or even I think there was some in Maryland when it came to like ethylene oxide. Just like where do we place the sensors? Can we get access to those sensors? Is that data reliable? And it raises for me, I guess, questions about like once you're in court, what are those questions about causation or traceability, or who is responsible for what? And that's something I'm coming up across a lot in my own work. And maybe that's something we can talk about in Q&A, or someone else can ask that question. But like there's a lot of challenges that come in this space. And so I'm glad that you guys are touching on so much of it. Any other thoughts?
Yeah.
Before we move on from the federal level.
The last thought that I had was the fact that some of the federal money that was being pushed out to communities could be used for testing and monitoring and hiring experts and bringing in more funds to pay for that. I mean, litigation is not cheap, especially where you have to prove causation and you need to collect data and get an expert who has to generate a report. So that's something else that is being lost with not having federal funds to support that.
That's such a good point. Any other thoughts?
Nope. No.
All right.
We're gonna talk about the state level.
Yeah, let's get into the states. So as we all know, the federal level is not the only place where we're seeing action on EJ. In fact, there's a lot happening right now at the state and tribal level, some of which we have listed here on the slide. I'm actually going to give our speakers a break, and I will be covering some of these state initiatives, and I'll be mostly talking about permitting laws, some of the state EJ mapping tools we were talking about, mini NEPAs or state-based NEPAs, some of the environmental rights amendments that Stacey was talking about as well, and kind of and then we'll get into like what model EJ laws or could look like in the states. Before I do so, I wanted to note especially that when it comes to environmental justice, like we're not just talking about on a state level, but also there's a lot of like tribal initiatives that are happening. I can't say that's my area of expertise, but I am like, as an Indigenous person, I care deeply about what's happening to Indigenous peoples on this continent, and thinking about how tribes, even though tribal, I always see Indigenous environmental justice as something that's very intertwined, but also can be very specific because of the nature of the relationship between tribes and the federal government and that kind of that treaty relationship. So Stacey, if you could kind of give us a little bit of what we should be looking at in terms of, for a baseline introductory of like, when it comes to tribal environmental justice.
Yeah, I mean, I think, again, someone who's not an expert in the area of the intersection of tribal sovereignty and tribal issues and environmental justice, I do see that sometimes these are siloed conversations, and there's a lot to be gained from bringing them together. I think this is going to become a particularly salient issue because of the focus on domestic energy development and manufacturing and reshoring, onshoring. That's going to become, a real fence line issue for a lot of different communities as the administration invests in that sort of development. And I think that's particularly true. We're talking about sale of federal lands or development on federal lands that may be very proximate, or resources are very proximate to tribal communities. So that's really going to raise very different legal questions about sovereignty, about litigation with tribes or engagement and negotiation with tribes, intersections of the private sector folks and the government and tribes that are, I think, very relevant to the environmental justice conversation. And that I feel should be ELI, a separate.
I completely agree.
A dedicated conversation there, but we didn't want to leave it out. Certainly wanted to flag it and can discuss it more in the Q&A if there are folks who are interested.
And especially if there are folks in the audience who like have like that knowledge and want to bring it into the conversation, would love that just as much, just because we're clearly not all like the only experts or experts entirely on EJ. So with that, I'm going to get into a couple slides here on state laws and give you guys some time to drink some water, take a break. And so what I have here for you all are a couple maps, I've got like 3 or so. I'm just a very visual person. I really love to be able to see like what EJ laws, cumulative impacts laws, like I need to see the visual of like how many states are doing it or have something in the books. So I'll start with EJ. I've definitely condensed a lot of my information here. Like it's just a generally like, have they enacted something related to EJ or have they proposed something related to EJ? So it's a little broad, but I'll try to get into the more specifics here with you all. In terms of like an EJ specific law that's been enacted, there are 14 states that have it. I'm not going to read out every single state or we'll be here forever. But like some of the examples you can see here are like California, Oregon, Washington, New York, New Jersey. You're going to hear a lot of kind of the same actors in these spaces. That being said, there are some that even though they don't have like a binding EJ law in place, there are some states that have some type of EJ task force or advisory council where EJ is being thought of, even if it's not being enforced. And we can see this in South Carolina, Vermont, and Michigan. There's some states where some type of EJ legislation has been proposed. We've seen this in Texas, especially. Some where permitting issues when it comes to EJ are making sure that EJ is a consideration or a required consideration in permitting has also been proposed in Georgia and in Texas. Unfortunately, both of those did not pass. This is also a good place to note that everything I'm listing here, I tried to update it as most recently as I can. But by all means, if you, anyone in the room knows that, oh, that's actually not up-to-date information, please share, just because this is constantly changing by the day, so it's hard to keep track of. If you do want to keep track of it, I use the Vermont's EJ state-by-state tracker, and we have it linked in the slides. In terms of, so we have like EJ laws, but then there's also just kind of some laws that are out there across the states that are either EJ related or equity related. And I have a few different examples here. We do have some of the climate laws that I'm sure Stacey will kind of bring up as well. And we'll get into some of the more specific examples. But there are specific state climate laws that are of course relevant to EJ communities. There's some wetlands legislation in New Mexico and Colorado with EJ considerations. Brownfields redevelopment with EJ explicitly mentioned in Florida and Kentucky. There's solid waste management facility permitting that considers EJ issues in North Carolina. There's an environmental stakeholder inclusion program in Indiana, and Arizona's DOJ is advancing EJ under Title VI as of February. I haven't checked on that one recently. And then as we've mentioned, some of these states on the left side map with the EJ map, some of them do have their own mapping tools. By my own count, it was recently 11 states that have their own mapping tools. I don't know if that's increased since the taking down of EJ screen. I'm sure my hope is that there will be more. So that's what EJ is looking like across the states. So there's something to hold on to, and hopefully some good legal hooks for litigators. And then the second map will kind of cover like some of the cumulative impacts laws. I would be remiss not to state that ELI just recently had a webinar, Cumulative Impacts, that was super useful and where I got a lot of this data. So I'm just reusing our old stuff because it was great stuff. We have 8 states that they've enacted some type of cumulative impact specific legislation. And you can see those here. Some of those are California, Colorado, Connecticut, New York, New Jersey, Vermont. Some that have it proposed or pending. There are 13 states that have proposed it. In terms of like Arizona, DC is actually one of them, just proposed one. Washington, Wisconsin, there's quite a few. Yes.
Question for you.
Yes.
How would you define a cumulative impact law?
That's a really great question.
Put you on the spot. But
So no, I will get into it. So it kind of varies. There's like a varying in strength with some of these states, and that's what I'm going to get into in a sec. No, you're so good. That's a really important question. I just want to highlight before I move on to that question that of these like kind of cumulative impacts developments, 6 states have done this in 2025. So Minnesota's just came into effect this year, and 5 states as of this year have proposed some type of cumulative impacts law. So it's very much like a very active space right now, and like we could see like a lot of shifts even by the end of the year is my hope. And so to get to Stacey's very important question, we're seeing kind of a different, when it comes to cumulative impacts, there's different types of laws where it could be required in permitting, for example, like in terms of environmental permits. There are 6 states that do just straight up require that you have to consider cumulative impacts. California and New York are some classic examples, but yeah, there's 6 that do that. And then there's 16 other states that have some type of language involving cumulative impacts. 7 of those, so like including DC, Georgia, Illinois, they have actually a shall consider type of language. So it's a stronger requirement on states. 9 others like Arizona, Colorado, Wisconsin have, you may consider it. So it's less, it's less strong or less useful, but nonetheless, it's still there. And it's currently in a time where we're like federally rolling all of those back. It's really nice to at least have that language in there, but that's my best answer to what cumulative impacts legislation would look like. I would definitely defer to that webinar if you're really curious. So there's some really great experts on cumulative impacts on that. And I do think I linked that on the slides. If not, I can, yeah, Sarah will put it in the chat, great. So that are those two maps. And then I just wanted to bring up a couple other things. So they're not stereotypically as much EJ, and yet they're quite relevant. We talked a lot about NEPA recently when it comes to federal NEPA. There are states with their own NEPA laws. What I want to highlight here is that there are, we call them mini NEPAs. And so there's quite a few states that have them. I see 17 here that have their own mini NEPA. But most of these, except for two, so not Indiana, not Maryland, everything else that's highlighted here, they have a cumulative impacts requirement or consideration in their mini NEPA, which is really important. And then some of these states have both a mini NEPA and an environmental rights amendment. Some just have an ERA, as you can see here, like Pennsylvania and Illinois. Those environmental rights amendments we can kind of get into a little bit later as well, but I just wanted to flag those as like some of the really interesting and kind of important cases in the climate space have been coming up with environmental rights amendments, specific like Held v. Montana is a classic example. A lot of the youth climate cases are bringing that up, and that's also a tool for EJ communities to use. So there are a myriad number of state initiatives, whether that's EJ specific, cumulative impacts, or NEPAs or ERAs that, you know, EJ advocates can and hopefully are using. But I want to get into some more specific examples. So I'm bringing you both up from the bench now. You know, given all that's going on at the federal level and given kind of some of these different state tools, I was hoping you can, Sheronda, if you can walk us through like some of the examples on what kind of progress we're seeing now with EJ at the states. And then Stacey, I will also want you to chime in when we get to the New York conversation, especially when it comes to climate related lawsuits and like state overreach.
Okay.
Take it away.
So I'll start here with the New Jersey law. They have an environmental justice law that requires their Department of Environmental Protection to evaluate the environment and public health impacts of certain facilities on overburdened communities and issue decisions on those facilities' permit applications. And under this law, I believe that they can flat out reject an application on the basis of impact on an overburdened community. So pushing for things like mitigation and helping to address those issues. But if it's going to impact negatively, that's kind of the strongest law that I've seen out there to get the application shut down. So shout out to New Jersey. We've been kind of leading on that issue, and a lot of states, I hope, are kind of looking towards that and trying to think about what that looks like in their state. We also have the California Environmental Quality Act, requiring that state and local agencies disclose and evaluate significant environmental impacts of proposed projects and adopting all feasible mitigation measures. So really making sure they're going the extra mile to evaluate these concerns, reduce the impacts on communities. So that's another great law as well. And then,
I do want to note here, as a Californian, it was a really great law, and it's not a bad law necessarily. There have been very recent developments, I think, in the last week or two. Someone might have already put it in the chat, but CEQA has been, I think they have new exemptions for quite a few industries. I can't get into the specifics, so I don't have them off the top of my head, but there has been
to be aware of.
no, yeah. So even some of our strongest state laws, I think, are still very much potentially under attack, or things that we have to keep an eye on to make sure that we're still using them, or that they'll still be available to us.
Yeah.
But yes, continue. Thank you.
Sure. And also highlighting the New York Climate Leadership and Community Protection Act. It mandates the prioritization of disadvantaged communities and environmental reviews. So, pretty clear and direct language there on prioritizing and making sure we avoid overlooking the marginalized communities and making sure that we are considering those as well. So I think Stacey's going to give us a little more detail on that.
Yeah, I think this is a fascinating space, just because, in the first Trump administration, there was such a strong swing at the state level with states like New Jersey's law in 2020. And even, the CLCPA in New York, which is focusing on, climate related issues, but was one of a string of laws that talked about, or that was the model for Justice 40, to take that percentage of benefits from climate investments and direct it to disadvantaged communities. I don't think any of this activity has gone unnoticed by the federal government and by the Trump administration specifically. So just note the review and repeal sorry, not the review and repeal, the DE&I order that I mentioned earlier, was a restoring quality of opportunity meritocracy, has an explicit provision that talks about finding situations where federal law preempts state laws that could make decisions that are unconstitutional on the basis of some of these DE&I related issues. So that seems like many of these state laws identify disadvantaged communities, overburdened communities, incorporating race and income, and that's the mapping tools. So that's something that is going to likely be in the crosshairs in the future from this administration. I think it's also worth flagging the executive order protecting American energy from state overreach, which explicitly calls out CLCPA as one of the laws that basically hinders American energy dominance as framed by the EO. And the EO targets things like permitting laws, or I think New York's climate change extortion law. So really just challenging some of these state-based efforts to invest in clean energy and to take climate investments in direct disadvantaged communities, and also to intensify permitting processes to think about potential impacts. So we can expect to see from this EO, the AGs, the Attorney General was directed to identify all state and local laws, regulations, causes of action, policies, and practices, burdening the identification, development, siting, production, or use of domestic energy resources that may or be unconstitutional, preempted by federal law, or otherwise unenforceable. Climate change, environmental, social, ESG initiatives, EJ, greenhouse gas emissions, other words that are flagged as targets for that analysis or for identification of those particular state laws. So again, this is the activity at the state level is really robust, but we're also going to see an intensification, I would expect, over the next few years of tensions between federal policy objectives in this space and state activity that will probably result in lots of litigation. So that's what's coming. I would flag, just as a context, and as yes, why is a private sector lawyer up here on this dais? But beyond that, just to play devil's advocate, I know we're seeing a lot of shifts in policy directions, even at the state level. And I think, this is a complex, as we all know, a complex area where you've got investments in certain types of energy. I mean, what is it? It's oil, natural gas, coal, hydropower, geothermal, biofuel, critical mineral, nuclear energy resources. So I know there's a lot of workforce development priorities for a lot of these states who are also balancing some of these equities in terms of, investment in EJ over the last couple of years versus thinking about other types of investments. So it's a complicated space with lots of opportunities and risks. So just underscoring that, politics aside.
I think that's a perfect way of putting it, and a good segue into thinking about what are the other legal tools that EJ communities or EJ advocates can look at that aren't necessarily only at the federal level. Like we've talked about what litigation tools there are for using environmental and non-environmental statutes, but can also get into the other aspects of law, especially for the law students in the room. How is this relevant to the classes that you've been taking? So I'm going to kick this to Sheronda, and then Stacey, if you can give us maybe like an example to kind of help this.
Sure. So I wanted to include these tools as, being available in the toolkit. We talked a lot about the statutory provisions that allow us to do some enforcement actions, but we also have these tools that have been used with varying success by EJ advocates and litigators. So starting out with public and private nuisance. So nuisance, interference with the use and enjoyment of property, and privately for individuals or generally on behalf of the larger public. So those are some actions that can be brought to address environmental concerns. And there are also negligence-based torts, strict liability torts. I know that, Margaret, you've worked on some toxic tort issues for ELI. And so those are available as well. And with torts, there's also been some raising of claims on bodily autonomy, and that can also relate to constitutional claims. So we've seen those as well. And I studied a bit the Flint cases that came about when I was in law school, and the constitutional claims of bodily integrity with the Flint water crisis and contaminants being released and essentially poisoning people. So that bodily autonomy claim at the constitutional level is something that's been used with success as well. So you also get into due process claims with the constitutional litigation in the space. So that's another method, as well as equal protection. And there are sometimes, as we mentioned, state environmental rights laws that can open up an avenue for some of these suits as well.
Yeah, it's really interesting. I think the last couple of years, and I think the years to come, seeing really creative legal arguments. I mean, use of the 13th and 14th Amendments, not just equal protection, but like legacy of slavery and conversations in Louisiana. Just really interesting stuff that's even surviving the Fifth Circuit, which is a little unexpected, to put it mildly. But Louisiana, I think, is a real laboratory for this kind of litigation, given all the industrial density in the area and the really sophisticated partnerships of a lot of the organizations there, like Rise St. James and the Tulane Law Clinic, and Earth Justice and other organizations are very present in those areas. But just wanted to flag the Rise St. James v. LDEQ case is one where the outcome's ultimately a permit challenge that the permits did remain in place, but the foundational aspects of the argument are really interesting. You've got the Louisiana public trust doctrine, which is essentially a state constitutional principle that says the state holds lands and its resources in trust for the public. And EJ groups challenge LDEQ permits for a plastics facility in St. James Parish, claiming that, among other things, LDEQ didn't adequately consider EJ considerations in the permits. The district court vacated the permits in about 2022, agreeing that the EJ analysis was lacking. LDEQ appealed and said, we don't have to consider environmental justice with the public trust doctrine. And the First Circuit in January reversed that, essentially said EJ is one of the factors under the public trust doctrine, which seems like a pretty big deal in a place like Louisiana, where you have this component of this duty ultimately to consider environmental justice impacts. That decision was challenged again in the Supreme Court, Louisiana Supreme Court, which denied the petitions from LDEQ and from the EJ group. So that's still in play and raises other questions of how are we going to see more creative state constitutional claims that use these sort of creative grounds to challenge permitting decisions, to challenge long-standing infrastructure and growing infrastructure, and sort of I work often with clients thinking about these issues. It's like, how do we, even if it's a small facility or an existing facility or a new permit or whatever, a long-standing permit, how do you think about where there are risks? And these are very much emerging risks to thinking about creative new legal arguments and opportunities for groups.
Exactly. All right. We've clearly covered a lot of ground today. So we're just gonna give a chance to kind of recap for everyone here in the room and online.
Does anyone need to stretch or anything?
Right. We've been at it for a while, y'all.
Yeah.
So I'm gonna kick this off to Sheronda. If you could recap for us, what are the current trends, and kind of give us an idea of what we should be keeping an eye on when it comes to the EJ space.
Sure. So we discussed a lot of court activity, right? Challenges to the actions at the federal level by environmental organizations, particularly with restoring the grant funding, but there are a range of cases there where we're seeing court activity. And while that's all ongoing at the state level, there continues to be movement and progress with getting legislation to support environmental justice concerns passed. Some states are focusing still on clean energy and moving away from coal and things like that. EJ-based funding by state legislatures to kind of fill the gaps, regardless of the federal rollbacks. Some states also have green workforce training and equity, which can bring benefits to environmental justice communities. And states are also reviewing EJ-focused workforce initiatives, development, and some infrastructure projects as well at the state level that can be beneficial. And just continued engagement civilly with our society, continuing to work on these issues through tribes, nonprofit organizations. Some of those projects are ongoing to address EJ concerns outside of what's going on at the federal space. So still some progress and high points. So we try to not be all doom and gloom, because the work is continuing. So we have to try and support the organizations that are kind of carrying the torch on that front.
So even that last bullet, the
Yeah,
engaged civil
that's it.
society
Mhm.
piece. What's been really interesting to watch is over the last, like the Biden administration created a lot of new national partnerships that weren't there before, like a group in New
Right.
Mexico, maybe you never talked to somebody in New York. And now these folks are talking to each other more regularly. And now in sort of a more oppositional posture, there's even more, I think, galvanizing across big national NGOs, environmental NGOs, and community organizations. And that sense of urgency is causing, I think, again, more unexpected bedfellows and a galvanizing way that was looked a certain way in the Biden administration, and now looks a different. Is sort of like a wartime posture. So it's interesting to see that groundswell come up. It's not as siloed regionally.
Oh, yeah, definitely have seen some cross collaboration with some organizations I've been working with. There's an event or an activity I participate in, and then it always leads into another event that's ongoing with another organization. So sharing resources, and when one group has capacity and ability to set up a framework for helping on the grant funding side, there's other organizations that can focus on targeted litigation on some of these rollbacks and effects from the executive orders that we're seeing at the agency level. So definitely more partnering, more resource sharing, and we have the ongoing day-to-day work, and also now coming in with the new legal challenges to manage. It takes time and resources, and it diverts from people's mission-based core when you have to kind of deal with some procedural issues and things at the federal level. So collaboration has become key to kind of maintaining during this time. So it's good to see it.
In the spirit of sharing resources, collaborating, I think it would be great to hear from both of you, particularly in your different roles and what you both do within the legal field. If you could give all of us, what are some ideas that we should have about what does it mean to engage with multiple stakeholders, engage with communities? What are the best practices for doing so? Because I do think you both have probably really interesting perspectives coming from kind of the more EJ space, kind of the more private sector space. What that would look like for best practices, especially thinking about EJ is not just this very current doom and gloom, as we said, but it's really not, and thinking about it more on a long-term strategic scale. Whoever wants to start.
Sure, I can start. So a lot of the concepts that I laid out on the front end of our discussion with the different aspects of environmental justice, and including communities in the process, having them engaged in decision-making, being aware of the social and historical issues that their communities face that have led to some of the issues that they have on a day-to-day basis, learning about that and making sure you are aware of it. So when you have early and inclusive planning and engagement, that's key. Talked a lot about collaborating, and where you're still able to do that at your state level, it's great to continue those conversations, to continue to elevate concerns of environmental justice communities, and work with other nonprofit groups. There are a number of organizations that do great work. We also have investment on the private sector side that Stacey can talk a little bit more about. But people still want to show up and do what's right and continue to address concerns of communities. I talked a little bit about outreach to communities when you provide public space, public hearings for doing that, making sure that there are resources provided in multiple languages. If you have a community that's predominantly Spanish speaking, making sure that they have access to materials in their native language. Data transparency, we talked a lot about the tools that we have available. So that's with state and local level, EJ screening tools. We have a lot of GIS capabilities at CVF. We have a great team that can help us with mapping out different areas and highlighting issues as well with GIS. And let's see, capacity building, supporting community-led monitoring, leadership training, community lawyering, and local EJ advocacy. So I always think about the concept of community lawyering more so as a listening role. You come in, you want to open up discussions with the community, hear about what is impacting them, and not just jump on EJ screen or a tool and go in and say, oh, your community is overburdened. Here, let me help you with that. I've studied the Clean Water Act. You don't want that to be the case. So I found a lot of times in my advocacy that people care about what's going on in their communities. They want to have their voices heard. They want to learn more about the processes and the resources that are available to them. So a lot of times I find myself kind of helping to connect people with resources. And when I'm working on certain issues, a lot of times I come across people who care about them just as much as I do. And so that I'm able to connect with them. I always tell the funny story about being at an Earth Day cleanup outside of DC and talking about, some of the work I was doing at CBF. And I wind up, sitting on someone's porch that afternoon talking about, their concerns about stormwater permitting, seeing their rain garden that got washed out. So just being a resource to the community, making sure that they feel that you are someone that they can trust and you have their interests at heart. So that's something I found, in my work that's really stuck with me, and I do enjoy it. And I kind of get to be chatty, so I don't mind like sitting on the porch on a Saturday and learning about people. But that also kind of opens the door to hear more about community issues. And I keep that in mind if something comes across my desk that I think that they would be interested in. I say, hey, about this going on, and we really get some, back and forth on different issues and updating and things like that.
Mm-hmm. Yeah, I mean, I think it's interesting doing environmental justice work in the private sector, especially I picked it up after coming back from EPA, where my work was primarily focused on the agency's response to Flint and the scrutiny of EPA's Title VI civil rights enforcement program. So that was sort of my, baptism by fire, sort of initial learnings on EJ, and then getting into the private sector considerations in the Trump administration, companies that really wanted to differentiate themselves from what they saw as a withdrawal from some of those sorts of programs. And I have to say, I am so privileged to work with incredible clients who many of them feel very passionately about these topics, and have to deal with really complicated multinational companies and investors and a lot of different stakeholders internally and externally to try and basically conduct internal education about the opportunities and risks of EJ related considerations. Because environmental justice up until 2021 wasn't a word that a lot of people knew. And a lot of the last couple of years have been not only educating internally to say, what does environmental justice mean for us? But what does it mean for our operations? What does it mean for our compliance program? What does it mean for our philanthropy program? How do we think about our operations generally? And how does this all fit together? This concept that we previously put over here and now, honestly, driven a lot by some of the carrots that the Biden administration put forward. It's like, okay, we have to figure out what a community benefits plan is now. What does that mean? What does a stakeholder analysis look like? So where initially in the last Trump administration, we're getting a lot of ESG sort of focused voluntary engagement, questions about how do we develop an EJ policy because we care, we want to set ourselves, use it sort of like a market differentiator or like identity differentiator. Then it was, oh, well, there's significant funding here. How do we think about this for us? Because there's a real benefit, not so much the stick or the enforcement or the reputational harm, but like, wow, this is something that we could use to make ourselves better, but also to be competitive. And I don't think you reverse that education. I think that's been something that, there are questions being asked internally now from folks who have learned over those 4 years in-house. Should we do a stakeholder analysis? What is environmental and social performance? How does that fit with a stakeholder analysis? How does that fit with our EJ policy or what we want to do for ESG or for community engagement or philanthropy? How do we measure impact? But bottom line, regardless of your politics, Margaret's maps are what they are. There are laws. EJ is law. There are bottom line compliance considerations that many of these companies have to make about permitting their facilities, about, just operating in states where there are complex and evolving environmental justice laws. So I think, as far as best practices, these are really important components here and have been sort of bedrock of EJ guidance for a long time. But for the regulated community, there's just hard and fast obligations in many of these states that I think that's the conversation for a lot of them. This is part of our compliance program. So I think these are important pieces, but it's also keeping track of, using maps like the one that Mark put together and stuff that Vermont, that Vermont is doing, sorry.
They'll forgive you.
Yeah. But all those different resources to track these developments, to really think about EJ as law, not just a voluntary nice to have or a binary, but like these are real concrete legal obligations.
Yeah, and you mentioned the education piece. So with educating your clients, I also like to educate people, with how to seek out their local zoning laws and how to monitor their developments. Being aware of that process and the stages that occur, so that they aren't just getting involved on the back end once something's already being proposed. Helping them learn how to go and see what's in the hopper, when's the hearing for that. Do you have a template I could use to develop some comments? Things like that are resources that organizations provide, either as part of their core mission, or some pro bono organizations help with that as well. Not only do I want to know how to navigate the law and how to litigate and bring a case, I want to empower a community to be able to raise their own voices and know how to get engaged and not kind of feel like everything has happened and progressed without them and they had no tools at their disposal. So, I'm going to work with you on an issue. I want to equip you with the tools to be able to monitor and address it in the future, whether I'm here to help you or not, just to educate and to empower the community and make sure that they have resources. If it's something that I don't have capacity to help with, connecting them with some of my colleagues who may be able to assist. So making sure that they are, informed and educated and have people to reach out to that they can trust is also important.
That's such a good point on land use, though. Sorry, it's like the zoning and land use piece, I feel like gets lost in the sauce in these conversations. But
yes, thinking about historically how that process has been carried out doesn't really have a lot of on the front end, baked into it with public participation. And we have the zoning in place and this goes over here, that goes over there, and how it's progressed historically is, this becomes the minority community because no one wants to live near that. Or, oh, we already put all of the factories over there, so we'll just put these over there now. And we won't kind of redistribute or deal with it. It's like, this is where all that goes. And so we just continue down that road and we end up with the overburdened communities, the multiple stressors, environmental factors that they face. So there's good folks working in the land use and zoning space to try and address how we deal with that going forward.
But I think even watching the proliferation of ordinances, local government level or zoning challenges, it's sort of like it's not the sexiest place to have the conflict, but in terms of, it's quiet. Like you don't necessarily, unless you have a project in that area or you're part of that community, you don't necessarily know about a zoning or like a permitting challenge at that level.
Right.
Or like an ordinance that prohibits CCUS development in a certain place. Like stuff like that I feel like is a little quieter. That can have really significant impacts either on the developer side or the community side.
Right. And also gets to like what EJ was about in the first place, which was about a local grassroots movement. Like it is about kind of the less sexy places to have those conflicts, but it starts with local communities and then gets to then we can talk about all these federal things, but at the end of the day, like it is about what's happening locally. Right. Take us home, y'all. What are the key takeaways for today? What do we want the audience to know? We've covered a lot of ground. We could literally be here all day, but at some point I do have to cut us off as we can finally get to some questions. I'll let both of you decide what you want to cover here.
Okay. Yeah, I feel like I kind of gave my perspective in my last response. And not on the slide, but overall, the takeaway is to continue engaging in the space, educate yourself, being here today and participating in this webinar online, a great step to keep yourself aware of developments, learn about, historically how the movement has progressed. I think about focusing on the high points, what has worked, use that as a model to kind of employ engagement going forward. It's the same thing they did with watching, Warren County and how they reacted to that landfill, and that kind of sparked a grassroots movement. We have to focus on what's going well for us and learn how to spread that and circulate it. And also, how do we protect it? How do we make it better? And think long-term about once we get through the space that we're in. I know we're all hoping that it's just going to be this 4-year term and then we can kind of begin our course correction, but thinking about what you want to be able to engage on once we get through this space, figuring out the political power to support your goals and efforts. aligning yourself with those people and kind of preparing, think ahead, think into the long term. If we have this here, yes, think long term, be an engaged stakeholder. Don't just complain about all that's happened and put it on someone else to be the onus to kind of begin that process. Think about, as a stakeholder and someone who's engaged on this front, what do you want to see? Where do you want the movement to go next? And what issues does your community need to have addressed? So say just be optimistic, think long term, and brainstorm, put on your thinking cap and think about solutions to some of the problems we're seeing.
Yeah, I'd say, it seems like a dizzying time, but when you look back to the Memphis sanitation workers strike and to Warren County, a lot of EJ aunties and uncles who are, maybe find this a challenging time, but this is just one point in time. This is a very long trajectory in this work. So thinking long-term, I have clients with 10, 15-year projects. This is a turbulent, challenging time to stay on top of, but this is, a drop in the bucket in terms of policy navigation. So it's hard, but it's, thinking long view, and not just reacting to what we're experiencing in the moment, which is, makes it sound easy, but I think it's something that's important to keep in mind. And stay informed, I guess, coming to things like this. So props to y'all for bearing with us on this journey.
Yeah, and continue that with, seeking out organizations in your community that you could support. Figure out ways that you could volunteer, whether you volunteer, actively spend your time, send a donation. All of that would be a great way to kind of help them kind of bide the tide until we get to the next period.
That's it in terms of the slides. If we could give a quick hand for our speakers. They've been doing a lot of talking. Thank you. So we do have time for Q&A, which is so great because there's a lot of questions in the chat. So I'm going to start with a couple questions that I'm seeing in the chat, and then I'll try to kind of bounce it back and forth. So start with 2 on the chat, and then I'll open it up to the room just because we can kind of hold you hostage a little bit longer. So I don't want to get to you just yet. I'm going to start with kind of 2 related questions that I was seeing in the chat. One is about kind of thinking about like the EJ terms that we were talking about towards the beginning. Specifically how we talked about like the administration's kind of threatening the use of certain language or certain terms. Do you see like there are debates about what's the right definition of EJ to use? Or if there are is it okay to kind of keep on with the EPA definition? Should we be coming up with different definitions or using different terms in this work? And I would say kind of a related question is really about kind of like the anti-science attitude that we've been seeing. If either of you have seen that, how it's impacting kind of either your specific EJ work or just kind of impacting the EJ movement in general. Because I do see those kind of as 2 related things, like the attacks on specific terms like DEI, but also kind of like on science in general, which has been like both are important tools. Do you see either of those things kind of playing a role in the work?
Well, I can, start with discussion of how, the changing terms and how we refer to environmental justice work might be changing, and to kind of get around, it's a taboo now. There's this negativity associated with it. And some groups are changing how they refer to environmental justice work. They might say, communities and partnerships, and refer to it in that way, because we want to continue working with our partners who might be less able to engage if something were labeled environmental justice, and thinking about it's more of a community engagement type of relationship. So outside of the term, really getting down to the core concepts and principles associated, with environmental justice. And if we know that words such as equity has been flagged, overburdened, marginalized, all of those, we kind of talk about them just in a different way, but at the core, it's the same concepts. So, yeah.
I mean, I think where you sit is where you stand, which is sort of to some point, to some degree, what you're saying. So it's, a lot of sort of the anti-DE&I executive orders, a lot of that activity right after the inauguration generate a lot of concern from clients about what does this mean, not just about EJ, but just generally about really forward-leaning DE&I policies or initiatives or ESG initiatives or climate efforts or commitments. And, sort of triggering a wholesale risk analysis of what do we need to do? What does this mean from a reputational perspective? If we're consumer facing, like if, a lot of longstanding industry has a very longstanding footprint and huge employee numbers in local communities. What does it mean if you shift course, if you change course? So balancing the challenges of, heavier scrutiny from federal regulators and the White House against, what we're seeing at the state level. If all of your facilities are in New Jersey, you have a complicated question in front of you. Just sort of trying to balance that out. Depends where you are, who your constituents or your stakeholders are, right? And what risks you need to balance alongside opportunities. Which is not a clear answer, it's the it depends answer, but
yeah, it's kind of a matter of knowing your audience, knowing your supporters, your base, if you're, in the NGL side. So that plays a role as well. Just the people you work with, they want you to continue working on these issues and being vocal, or if they prefer more of a lay low approach.
Right.
So,
yeah.
I think it also gets to the long view perspective of like, you could just react to all of this targeting and, to continue to kind of go with the flow, or say, in terms of science, like what's defensible, what works for us, how do we right size an approach that we can use going forward, then defend. Because like enforcement action, even litigation, a lot of that stuff is attenuated from the moment that it happens. It's 2, 3, 4, 5 years later,
Exactly.
right?
Yeah.
So Trump may no longer be president when some of this stuff comes home to roost. So thinking about, if we're going to adjust course, how do we do that thoughtfully in a way that we can defend years from now?
That's great. Thank you both. I've got probably 2 more questions I want to at least get to in the chat, and then I'll open it up in the room. So those in the room start ruminating. One question. Do either of you have thoughts on, anticipate how the Supreme Court's recent decision about nationwide injunctions, this is the case about birthright citizenship, will it impact EJ? If so, how? I don't have an answer to this, but I selfishly would love to hear any thoughts you might have.
Class actions, woo. I think the short answer is definitely yes, but that's going to have reverberations far beyond EJ in terms of challenges to. But I do think, the court made it pretty clear that class actions would be an option, and I think that's something we're getting past class, or it's just sort of shifts the approach. But I don't litigate as much anymore. I'm a recovered litigator. So.
I don't have any thoughts on that specifically, but I do agree with you on that point. Yeah, class actions.
One more, and this, I guess it could be for either of you, but possibly for Sheronda, given the work that you do. Have you seen examples of where communities have provided data that states may not have originally considered, but was given some weight and then considered reliable, whether by an agency or local government in court? And I think maybe this is like a chance to kind of clarify like what, kind of that conversation we were having earlier about data not always being seen as reliable, whether that's by an agency, a local government, state government. Maybe you can just kind of speak to that more broadly.
Sure, I'm mainly seeing this in the context of air quality monitoring, where monitors placed in communities, and water quality testing. So there's a lot of local groups, a lot of river keepers or water keepers who watch their local waters. They go out and collect samples and conduct testing. So that's typically the type of data that we're talking about with air and water. It might be soil that they take from, downstream of a facility that they think is leaching some sort of pollutant. So that's kind of where I've seen it: air, soil, water, having that testing done. Sometimes they get third-party testers who can maybe try and certify what they've collected with their kind of citizen collecting kits. But to kind of put it very simply, but that's where I've seen that.
Sure. Nice. I'm going to open it up to our room now. Do we have a mic for people? If not, I'm happy to repeat questions just to make sure it's heard. Yeah, that's much easier. Open it up. I'm going to go in the front and then the back.
So my question is, you both said, you brought up the tribal component of all of this and how the sovereignty is one way to go and maintain that relationship with the federal government. But on the other side of that is everybody lumping tribes in with DEI.
Yeah.
Making that. So are there national organizations you're working with or know of that are helping tribal governments, tribal citizens through these issues?
I'm gonna repeat, the question was about if there are, national organizations helping tribes specifically with, these EJ issues.
I can feel friends of mine in the community and nonprofit space wanting to smack me upside my head for not tracking this more closely and having a better answer for your question. A lot of my go-to, I felt like the WEJAC list did have some tribal organizations or tribal facing organizations that I think have sort of escalated activities across the EJ family. That would be if I was going to start that research, that would be the starting point that I would look to. I think We Act is also put together. They got involved at the COP at the global climate gathering. And I think they put together sort of a network of organizations that I think also involves tribal and indigenous groups. So that's another place where I would look. They have a network that I think is pretty active. So that's a terrible answer to your question. I would also love us to follow up on that because I think we can probably find something more on point.
Do you have anything, Sheronda?
Nothing that I'm certain on. So if I can find some resources, we'll share those. Yeah.
I think I don't have any specific resources. I do know that Earth Justice has like a tribal partnerships and policy like office. So I know like there are kind of these like bigger green like nonprofits that are doing like they have either tribal specific offices or tribal specific work. I am not an expert in tribal law, but I'm also would be remiss not to say that tribes do also have their own representation and tribes are also putting forward like their own litigation as well. So I'm sure there are like national organizations that kind of bring those attorneys together, but I haven't worked in that space or taken classes on that. But I do think we should come back to that, and it's an important dimension in that conversation.
I would be remiss if I didn't flag, sorry for looking at my phone, I'm actually looking at something relevant. A colleague of mine, Robert Conrad, shameless plug, I think is one of the co-chairs of ABA's Indigenous Law. No, it's not that one. I think SEER has a particular section on energy, environment, energy and resources. Has a more dedicated group, and he would certainly know. And obviously, the American Bar Association is a national organization, but that wouldn't be necessarily as community work facing, but would be focused more on legal questions of sovereignty and intersections here. So I'll also connect you with Robert if that's helpful.
Okay, if we get to our question in the back, I'll come up here.
Thank you. I was curious if on the community lawyer piece, if either of you have dealt with a situation where folks in a community just agreed on solution they wanted was, or if, for example, an industry comes in and half the community wants them to stay because of job opportunities, the other half doesn't want the environmental effects, things of that nature. If you've ever dealt with that, and if so, how did you navigate?
Just going to repeat it for those online. So the question is about whether our panelists have seen any instances of communities, EJ communities, not necessarily agreeing on what a remedy would be, or I think, and I can see generally, like, obviously communities are not monolithic, and you're like curious about like what are those tensions when communities don't necessarily agree on what's the right path forward for addressing an issue, and what you come across, what you think on that.
Right, that definitely comes up. I don't have any specific cases from my practice, but I'm pretty sure that everyone tries their best to compromise and meet both parties, where they are, and think about if we are going to have this industry here, there are benefits. How do we deal with the detriments that come along with that? What are some ways that we can mitigate the harm? Are there ways that we can encourage the facility to operate? Maybe it's restricting it to certain times of the day where maybe it's less hot and it's less likely to have more harmful effects than whatever they're emitting. So you think about operationally how we have both. Because I think most times we end up having to have that and figure it out along the way. So thinking about how they can best operate, we have this concept of being a good neighbor and getting the corporate industry side to consider that as well. Some states do a bit more of, stick than the carrot in terms of having companies comply with certain standards or operate in a certain manner. So I think that's kind of where you strike that balance, is trying to connect directly with the industry, right? Engaging your local regulators in that process. It might be something where you engage your elected officials and try to work through some of these issues, but hearing out all sides, getting all perspectives, and trying to come up with a happy medium and just get a game plan. And a lot of times with these discussions, you just need to have everyone kind of in the room sharing their concerns and perspectives and figure out where you can meet some common ground and compromise on things.
Yeah, like my mentor, Ben Wilson, he's a EJ professor at Howard Law and former chairman of Beveridge-Dunn. He would always say the self-appointed leaders of a community are not necessarily the ones who speak for the whole community. So your point of, community is not a monolith is an important one. And I think that's where, on the regulated community side, it's more encouraging the folks that I'm working with to say that's why it's important to have a good stakeholder analysis to make sure that you're really ground truthing the data that you've initially got, get on the ground and actually meet those communities and talk to as many people as you can so that you have the benefit of all those perspectives when you're thinking about mitigation strategies or investing in a community in a way that's meaningful. It really helps you build out all of those different, sometimes conflicting perspectives and try and get to an outcome that's not only equitable, but really appreciates the inputs that you're getting, good inputs to get good outputs. So
That's a really good point. It reminds me a lot of the work I've done, like in Indigenous people spaces, where we're talking about things like free, prior, and informed consent, which is a key part of, I think, EJR is like not as talked about in the conversation, but internationally it very much is like just a generally environmental human rights. In order to get that free, prior, and informed consent, you do have to make sure that you're doing that type of stakeholder analysis that you were talking about. So really glad we both touched on that. And that was a great question. Thank you.
Yeah, that comes up too when you think about some land use and zoning issues. What do
Yes.
people want to see in their communities? So I know that's been an issue in the jurisdiction where I live out in Prince George's County about the type of developments coming in. You think about having, a mix, and there's goals for transit-oriented development. We also have to think about a housing shortage and the cost of housing. All of those different factors come in, and it's hard to manage them all. But having that conversation, having elected officials that are going to ask the good questions, and agencies that involve the public in a meaningful way in the process. I know at my time at the commission, there were always public meetings offered at different times of day, different days of the week. You have weekend and weekday opportunities just to make sure that you are providing space to have more inclusive conversation from people in all backgrounds.
I want to get to the next question. I just want to bring up one point that I saw from the chat to our first question in the room in terms of like what organizations are working for tribal groups. The Native American Rights Fund, I can't believe I forgot to mention them, but someone else in the chat brought them up. So that's great. Definitely look into the work that they're doing. I can't say if it's EJ specific, but there's definitely a lot of work that they do, and they are kind of more nationally focused. So they'll be the right people to ask those questions too. One more question in the room.
Yes.
And I'll look online again.
Hello, everyone. And to your point, I used to work with Sierra Club, and one of the organizations that we work with is called the Indigenous Environmental Network. They're relatively popular, just in case you. I was going to ask a question about watershed governance and the idea of, say, how states could work together to operate and to kind of help manage shared resources, especially now where it could be pooling resources as well. But I have to admit, I'm going to have to shift to a slightly more selfish question, which is just that I'm currently working in sea level rise research and communications, and I'm interested in potentially pursuing urban planning and law. You mentioned kind of some zoning issues, but we can even talk about water infrastructure, energy infrastructure, food systems, all this kind of stuff, right? Just kind of wondering, do you have any advice for how I could potentially navigate this next step of urban planning and law? Do you have any organizations or anything you point towards to help form with that?
Can I actually piggyback that question? I'm going to assume people heard you online because your voice definitely carried, but just in case, Oh, did I get a thumbs up? Yes to repeat?
Yeah.
Mic was on. We're cool. We're good. I do want to add on to a question I saw in the chat that was also from someone thinking about law school. This is actually from a rising 3L, but curious about like if they want to do EJ work, but they're worried there might not be a spot for them in the current political climate and thinking about like federal and state hiring freezes, like what advice you might have for law students. And I think generally you can kind of get to the question, or maybe people who are thinking about law school. So I just want to put kind of those two questions together since what's your general career advice for all the young people in the room and online?
But the water question's gotta
The
go.
water question is definitely,
Yeah,
Sheronda, yeah.
But
You can
you
go
said you
through
want
that.
to more so focus on how you prepare yourself, and we can talk about the water question offline,
Yeah,
but I would say what I found most helpful was exposing myself to kind of the realm of what's out there. So, during my time at the commission, learning about planning and zoning, and there are resources and tools out there that may not be intended for you, but are very helpful. So there was like a training for people who are coming to work in planning. There's like a training document in Maryland. So I would like review that and familiarize myself with it. And when you attend public meetings or sit in on hearings and hear the arguments that people are raising, a lot of my days spent out in Annapolis listening to debate over legislation and hearing all of the different perspectives. I always found so many different resources and education tools that I could then refer to, and just keeping up with different events and things that are happening, understanding the context of how they all play together. I think the more that I, expose myself to that and kind of did some follow-up research, making those efforts and trying to give yourself whatever, maybe some sort of shadowing experience, or actually doing the work. And that can come through volunteering or being a member of a certain organization. So I would say that would be very helpful. And yeah, just exposure and education. Like the more you're around it and the more you kind of read about different articles and different sources, I think that's kind of what has helped me, because I find that I'm aware of certain things that I didn't think I would remember, but just that exposure and having worked and listened to debate on certain issues is very helpful. And then it can also help you figure out what most interests you. So when you get a certain subject and your eyes glaze over, it's like when I took Clean Air Act in law school, and I told everyone, I was like, it's not for me. I want to be aware of it, but it's just I zone out in a way that I do not with the Clean Water Act. So you also learn that as well, get that perspective on what you most enjoy.
Yeah, the exposure piece I completely agree with. I mean, I think in the thinking about municipalities and big cities navigating some of the issues that you're talking about, finding those cities and looking to the extent you haven't already at their guidance documents, what they've been navigating. Like New York City has an entire EJ effort that has some robust guidance. Like Chicago's been going through a lot, obviously, with EJ. So looking at sort of what they're navigating, how they navigate it procedurally, and how that all plays out. Getting the Google alert or finding organizations like the Sabin Center, or like if you're talking about EJ specifically in these issues, trying to find, if it's Georgetown, Harvard, any of the particular institutions that are writing a lot about these issues, and making sure that you're signed up for any of their alerts and their socials, and also setting up a Google alert that talks about those key phrases. And then what you're doing here, like the lived experience of meeting. It's a small pond, no pun intended, and a lot of us know each other through these watering holes of ELI or ABA, or through organizations that bring together EJ stakeholders across different disciplines. I think state agencies are making more efforts too to have sort of public forums to talk about these topics. So making sure that you're in the mix there, to the extent you have the bandwidth and time, I think pays dividends, because you'll meet people that will be in your life in ways that you could never expect years down the road. Real testament to that. So
yeah, and I'll just add that if you see someone who's doing exactly what you want to do,
Yeah.
don't hesitate to reach out to them.
Honestly, yeah.
Yeah. Reach out to them. I think, I've seen it a lot with students in the younger generation being hesitant to bother someone, but people love talking about what they do, especially when they're working in spaces where, it's work that they have a passion for. So yeah, make that connection. And I would say connections have been key in my career, and maintaining those, and you get a lot of benefits out of it. So, sure.
We have time for one more question.
Yeah.
We can get it from the room. Does anyone? If not, I can ask one last question. I am curious what both of you think moving forward looks like. Let's say in an ideal world, things are different in 2028. What does course correction, I guess, look like? So we talked about like, what's happened with all the gains that were made in the Biden administration. Is it enough to just reinstate, or how much further do we want to go? What could EJ governance kind of look like in a different administration, maybe? I hate a counterfactual question, but I like to end on a more hopeful note, I guess, that there's still a lot of work to be done.
I mean, I think, again, there's a lot of movement right now, a lot of noise, a lot of new questions raised. And I think the optimist in me struggles to say this is really an opportunity for us to step back.
Yeah.
And think about, what is this practice? What does this work look like? I mean, 10 years ago, never would have thought that I could practice environmental justice. In my former firm, worked to create an EJ practice. That was a wild concept.
Right.
And when I was DPA, I still have former colleagues that looked at me a little sideways, like, what does that even mean? So I think, this work exists in a lot of different contexts. And this is like the disappearance of EJ screen is an opportunity to step back and say, how do we look at data effectively for project development, for community advocacy? How do we look at citizen science? How do we step back and to not be so much, wrapped with the momentum of all those opportunities for those 4 years with the Biden administration, step back and say, how do we recalibrate some of this, either at the state level with state legislation or with data tools? So I think it's an opportunity to really think through some of the nuances here.
So thinking about how we perfect maybe some of these state laws, and then we'll have a little bit of time to have monitored how they played out, get some lessons learned that we can implement going forward, try and restore some of the losses at the federal level, and continue to think about, the definition of environmental justice. And we want to stick with the version that EPA put forth that's largely used today, or do we want to tweak that so that we feel it's more effective and inclusive? So I think brainstorming on how we can improve on some of the shortcomings that we've seen in environmental justice and kind of improve our systems and processes would be one plan.
And here's some real optimism. Get a side up from both of you. But maybe this is an opportunity for more stakeholders to come together from across the V and talk about what that might look like.
Yeah.
Because there is a bit of a vacuum in leadership on that conversation, I think, nationally. So maybe getting more of us around the table like this, forums like ELI, as a way to bring together folks who might not necessarily agree on all the angles, but at least are talking about it.
Right.
And I will add that with the loss of some of the funding and working on initiatives nationwide, I think people have realized that it's not just, the community that I don't live in, a Black, brown, poor community. It's impacted people more widely. It's in, rural states, it's in more urban areas. So seeing the common issues on both sides and kind of having some common ground on realizing, oh, I didn't think this was something that would benefit my community, but it did. So maybe I should think more deeply about the need to continue this and what it means for other communities who don't have, the same problems that I do. So I think people are having that kind of eye-opening moment too.
All right, that brings us to the end of our panel. Thank you so much to everyone, especially thank you to our speakers.
Thank you to our
Yeah, we just have Madison take us out.
Yes, thank you so much to our two wonderful speakers and Margaret for moderating. We so appreciate having you here today. Thank you as well to our audience for tuning in, whether you're here online or in person. We will have 2 more sessions in summer school, but they will both be webinar only. So we'll put that in the chat for the online folks. And just a huge thank you, Sheronda and Stacey. So appreciate it. Have a good day, everyone.
Thank you, Eli.
Thank you.